Hello, what's your name?
How you doing, Ray Sean Dawson?
Thank you. All right, what are we doing? Nice of you to arrive.
Defendants on behalf of Mr. Dawson. We are going to be requesting an adjournment. Mr. Dawson's, we could not reach him this week. We also just got extra video on his case, so we'll need to review that on my case, Your Honor.
And we're just requesting an adjournment to track the cases together.
Public cause conference, October 30th, 2025, 9 a.m. Bond continued on both matters.
Your Honor, can I address Mr. Dawson real quick about his contact information?
His contact information? You need him to contact you guys?
Just
Mr. Dawson,
Yes,
I need you
sir.
to call the public defender's office. Their
Okay.
number is
have my phone.
694-6970.
Say it
You
one
need
more
to
time,
give-
Judge. Say it one more time, Judge. Okay. Okay. I got it, sir.
Call there, make sure that they have a good phone number and email address for yourself.
Yes, sir. I got you.
Thank you. You need to do that right when you hang up,
I will.
and I'll be checking.
Who's the lawyer? Who do I ask for?
Mr. Dawson, we've talked so many
You
times.
don't have to, you do not have to ask for anybody. Just make sure they got your correct information.
Yes, sir. I got you.
Thank you.
Thank you.
Thank you, Your Honor.
I just had to be here all day. Court calls the case, People versus, is it Joya Wallace Taylor? Joya?
Sherilyn Foster Tucker on
That's too
behalf.
many letters.
Fine.
Fine, I'll do it when she gets up there. Go ahead.
Joya Wallace Taylor.
State your name.
Joya Wallace Taylor. Joya Wallace Taylor.
No, I heard you.
Oh,
I'm just in my head. Why do you have the 3 letters at the end? That's a lot,
I know.
right?
That's
You,
the first
you talk to anybody about that? Okay.
I need to.
All right.
I had to learn how to spell that.
You corrected me. I don't know what that's. All right. What are we doing?
Your Honor, you should have a plea form.
A plea form? Yes, I do.
That's correct, Your Honor. The people are adding an account to it, distributing fees, 750-170, misdemeanor, or $500 fine. Upon a successful plea to that, count 1, possession of the taser, or the felony would be dismissed as long as the defendant does agree to forfeit the taser. Did you believe it's already in police custody?
That is correct, Your Honor.
Is that sworn?
Right here. You solemnly swear to affirm that what you're about to give will be the truth, whole truth, and nothing but the truth, self you got. Thank you, man.
Joya Wallace Taylor.
Ma'am, it's this court's understanding that you're going to plead guilty to the charge of disturbing the peace.
We just went from a routine adjournment to a plea hearing. And plea hearings are where people lock themselves into criminal convictions in under 5 minutes. Pay attention to how carefully the judge starts walking through rights. This is the point of no return.
That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. And all of that, still wish to plead guilty? And to that charge, how do you plead?
You have to speak.
Oh, guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you're guilty?
Yes.
On the date of June 22nd, 2024, at the location of 2954 Washtenaw Avenue, Pittsfield, or Ypsilanti Township, Washtenaw County, State of Michigan. What did you do that makes you think you're guilty of disturbing the peace?
I had a taser.
Okay. Were you around a group of people?
Yes.
Did something happen?
Yes.
Did you pull the taser out?
No.
Did you show the taser?
No.
Okay. Somebody might want to wonder.
Were you involved in an altercation with another person?
Yes.
And did the police respond out?
Yes.
Did they find that the taser was in your possession?
I didn't pull it out, but yeah.
The fight itself, well, I can take the higher.
We're not charged, the fight didn't get charged, Your Honor, but, they
Okay.
did find it in her possession as a result of being contacted for that.
All right, I'll take the factual basis to the higher charge.
Thank you, Your Honor.
All right. Ma'am, I would have to advise you that if between now, the time of the acceptance of the plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, that any sentence evaluation or recommendation the court would no longer be bound by, and you would not be entitled to withdraw your plea. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
November 13th at 10 a.m.
November 13th, 2025, 10 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you.
Mhm.
Joya, your bond is continued. Go on. Court does call the case. People versus Stacy Lincoln.
David I. Goldstein appearing on behalf of the defendant.
She's pleading guilty to disturbing the peace, but the whole story revolves around a taser during a fight. That's called a plea bargain downgrade. The felony disappears, the misdemeanor stays, and everybody quietly agrees not to talk about how bad the original charge looked. Viewers, would you take this deal or risk trial with a taser in the story?
Your Honor, we have not yet received the discovery. I did discuss that with Mr. Maybell this morning. He indicated it would be forwarded to me, so we're asking for a brief adjournment.
Your name, sir.
Stacy Lincoln.
Thank you. Probable cause conference, October 30th.
Let me check, Your Honor. That'll work.
2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Jaron Jacobs.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Jacobs. Mr. Jacobs, could you please state your name for the court?
Jaron Jacobs.
We're asking for a short adjournment, Your Honor. We're going to resolve this case and just need a little time.
Probable cause conference, October 30th, 2025, 9 a.m. Bond continued.
Could I ask one thing about bond, Your Honor, please?
Go ahead.
Mr. Jacobs is wearing a scram tether right now. We're asking for the court's consideration to transfer him to SoberLink testing. He works for Lush Lawn. It's a landscaping company. He wears heavy boots for the work that he does. It's not like impossible to wear both at the same time. It's just very difficult. So hoping he can test several times a day with a SoberLink in its place.
Any response from the people?
Maybe to your discretion, Your Honor.
Why was he put on a scram in the first place?
I don't have any.
Violations, so my notes, there is count 2 is alleged possession of a weapon.
Do you have a BAC when he had that possession? Because now I can understand why he's placed on a scram.
No, there is not.
Motion for change in bond is denied at this time. Thank you. Court calls case of the people versus Kelvin Patterson.
Hey, Your Honor, Christopher Boger on behalf of Calvin Patterson. Mr. Patterson, please say your name for the record.
Calvin Patterson.
And Your Honor, we did have the opportunity to speak to the prosecution regarding this matter. We are asking for an adjournment. There is still some outstanding
Fill
discovery.
out a green sheet.
No, Your Honor.
Probably should have told you to do that.
I forgot. I apologize.
No, it wasn't your fault. It's all these people. They should have helped him out. How much time are you looking for?
Your Honor, are they held on Thursdays?
November 6th, Your Honor, if possible.
A month? On a weapons case, what do we do? What, I don't know.
I will let the court know as well, the defendant at the time was arrested on September 26th, which is a couple weeks ago. There's an OWI connect, because this is, we don't have the lab back yet, so I do expect we're gonna have OWI of those.
Come
Show
back.
what I think that they're gonna show based on what I can read.
All right, I'll give it November 6th, 2025, 9 a.m. bound continued.
Thank you, Your Honor.
I'll sign the green sheet when it gets. Court calls case of the people versus Earl Haynes.
Assistant Public Defender Davy Lebo on behalf of Mr. Haynes, who stands to my right. Mr. Haynes, could you state your name, sir?
Earl Haynes? Just make sure they're out. All right.
And Your Honor, we're requesting an adjournment. We're still engaging in some plea discussions.
Conference October 30th, 2025, 9 a.m. Bound continued.
Thank you, Your Honor.
Court calls case of the people versus Carlos Hicks.
Assistant Public Defender Jay Bellinger on behalf of Mr. Hicks, who approaches. Mr. Hicks, can you please state your name for the record?
Hicks. Thank you.
And Your Honor, I am just asking for a 2 to 3 week adjournment. I have asked prosecution to look into an aspect of one of his cases, and I'm trying to negotiate on the other.
October 23rd, 2025, 9 a.m. Bound continued. Both cases.
Thank you, Your Honor. I'll be in touch.
Court does call the case of people versus Randy Hockenberry.
And then on behalf of people.
Assistant Public Defender Sandra Wright on behalf of Randy Hockenberry. Can you state the record?
Thank you, sir.
Your Honor, I'm asking for an adjournment. There's some investigating I want to do and to speak with the prosecutor.
Without objection, probable cause conference October 30th, 2025, 9 a.m. Bound continued.
Thank you, Your Honor.
Court calls case of the people versus Dexter Hubbard. Barry. Yeah, you two shouldn't be together. I'm just saying. I think you guys know why, but I'm just saying. Go ahead. Yeah, just as that wasn't a good thing happened.
Sorry, Judge. Good afternoon, Assistant Public Defender Lauren Pearney on behalf of Mr. Hubbard. Mr. Hubbard, state your name for the record, please.
Dexter Hubbard.
We're asking for an exam date, Your Honor.
All discoveries complete.
Yes.
People have their witnesses available the 21st. Preliminary examination will be set October 21st, 2025, 9 a.m. That's before me. Bond will continue. Thank you. That's an in-person hearing, sir. Court does call the case of people. Andra Hunter.
Assistant Public Defender Davy Lebo for Mr. Hunter, who's approaching to my right.
Your name, sir?
Mr. Andrew Hunter.
Thank you.
And Your Honor, we did just receive the media in this matter. There are about 26 videos we need to review, so we'll be asking for an adjournment for that purpose.
October 23rd, 2025, 9 a.m. Bound continue.
Thank you, Your Honor.
Calls case people versus Amanda James.
Assistant Public Defender Davy Lebo for Ms. James. Ms. James, are you present, ma'am? Your Honor, may I go check the hallway for her?
No. Did you look before?
Yes,
Have you seen her today?
I have not.
Okay, then I doubt she's out there.
Well, Your
She's
Honor,
out there, you can do a warrant recall. Bench warrant will issue for defendant's failure to appear, bound set in the amount of 10,000 cash surety.
thank you, Your Honor.
That warrant will issue immediately. Calls the case, People versus Anthony Johnson.
Assistant Public Defender Sandra White on behalf of Anthony Johnson.
Johnson's here. He wasn't in the hallway.
Oh, I
Wait, go
know.
ahead. I'm just saying.
I want to go help my
Your name, sir? Anthony Johnson. Thank you.
Your Honor, we're asking for an adjournment for further negotiations. Prosecutor, he has requested some information from me.
Pardon?
He has requested some information from me.
Probable cause conference, October 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you. Thank you, sir. Court calls the case of the People versus Christopher Kosnick.
People. Chairman, I on behalf of Mr. Kosnick, who should be appearing by Zoom. Is he not? Sorry? Oh, I just called him 2 minutes ago. He said.
Did you?
Yeah,
Did he answer?
he did answer.
He's not here, though.
Would Your Honor pass it? He literally told me I need a minute to log in. He was ready to log in at 12:30. I told him to hold off on it. So it's actually my fault.
Okay, then the bench warrant will be your fault. What?
Oh, that is Mr.
He's here.
Christopher Kosnick.
Did he finally check in?
There's a galaxy that we just let in. He wouldn't have heard what he's called. That's him.
How do you know?
She has him.
How do you know?
He's,
How do you know? How do you know? How do, yeah, I know. So why are you butting in? Why? What?
He's the best.
Mr. Kosnick?
Yes, Your Honor.
I figured it was you. We waited.
My apologies, Your Honor.
It's okay.
My apologies.
You're fine. Your attorney's got issues, but you're fine. All right. What are you doing today?
Your Honor, we are waiving preliminary examination.
All right. Is that correct, Mr. Kosnick? You're waiving your right to a preliminary exam?
Yes, Your Honor. I am following the advice of my counsel.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense of stalking was, as alleged, was committed and that you committed it. You understand that?
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on a single count.
We were from reading of the charges and standing, Your Honor.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
December 4th at 1:30 with Judge Slay.
December 4th, 2025, 1:30, Judge Slay.
Thank you, Your Honor. I appreciate you.
Thank you, sir. Bond will continue.
Thank you, Your Honor.
I don't know. If you're asking, I get an option what to say, right? Court does call the case, People versus, this writing is killing me. Osandu, this guy.
Yes, Your Honor.
Like
An assistant public defender, Nicholas Bukovitz, on behalf of Mr. Wakaka, who's appearing via Zoom.
Nikaka. State your name, sir. There you are.
Osandu Likaka.
Okay, thank you. All right. What are you asking for adjournment?
Yes, an adjournment to continue some negotiations with the prosecutor.
Probable cause conference in this case will be adjourned October 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the People versus Derek Shipman.
That's all, people.
Assistant Public Defender Sandra White on behalf of Derek. Take me for the record.
Derek Shipman.
What are we doing?
Your Honor, we're requesting a preliminary exam in this matter.
Discovery is complete.
Yes, Your Honor, to the best of my knowledge.
Court received the bond findings report.
I am. People have their witnesses available the 21st.
You know, we can try for that date. I had extended a plea form. plea offer to the defendant, so I just was surprised to hear the question was there, but we'll try for that date.
October 21st, 2025, 9 a.m. before me. We have a bond violation. Have you seen that, counsel?
I have not discussed it with Mr. Shipman. It's my understanding they're requesting extra testing. I've talked to Mr. Shipman and I have now lots of medical documentation. Mr. Shipman has, due to medication and medical issues, he falls asleep at different times and is unable to awaken. I can provide the documentation to the court and to the prosecutor.
He needs to, first of all, make sure that he can make some payment. He needs to pay on his balance over there. This is rather outrageous, his balance that he owes over at Community Corrections. With reference to his testing, you're indicating then no matter how many tests he have, he's gonna have issues?
They've changed, he's asked to be taken off of one medication and the doctor has taken him off of that one. So he's hoping that.
Well, why wouldn't I just put him on a scram?
Your Honor, I have medical documents. They try to do that before I have issues with my legs. Everything is in the folder that I brought today. I thought she was gonna hand it to you.
That what?
I thought she was going to hand it to you. I have all my documentation in the folder that I gave to my attorney.
As I stated, he just provided me with documentation
Of what?
from his doctor stating his different medical issues.
I understand that, but that doesn't get me to his testing.
That's why he falls asleep. He's unable to awaken at the hours that he's now has to test. And adding additional hours won't help it. But I understand you still want him to test.
Well, here are the options.
Okay.
The options is he can go on a scram. I can add additional hours, or I can revoke his bond and put him in jail. Those are his options. Which one would you like?
The additional testing will be fine, Your Honor. But I did want to ask for one request. My doctor did ask if it could be adjusted from the 6 to 9 to 8 to 11. That would give me a chance to be able to wake up and not miss any more tests. And again, I do have the documentation from.
You're on 3 times a day per testing now, or 2 times?
One time in the morning. At first it was 3, then I got it down to 1.
He tests 1 time a day.
In the morning.
Who put it down to 1?
I'm on probation at the 15th, and I've been doing it since.
Oh, dear.
I think the court should be aware this is an OWI where the defendant is charged with trafficking, which no bank pass out of the bill, BAC .182, and then has a RNO attached to that. When he had contacted the police, I would request a scram. I have the same concerns the court has expressed about if there's issues with being able to be awake to complete tests, then I think continuous alcohol monitoring is the best and most appropriate way to keep communities safe.
He's testing 1 time per day?
Yes, Your Honor. If we could just adjust that to 8 to 11, 8 to.
No, 1 time per, I don't even understand why bother. It's 1 time, that is totally philosophically against. I realize some courts do it. I know that's not how I roll. So I'm going to. Here's what I'll do. We'll set it. I'll set the preliminary exam. We'll have it on the 21st. That's before me in person. I'm signing a new community corrections order. You're going to test 3 times per day.
Yes, sir.
That's a sober link. He says he medically can't handle a scram. Thank you, Bond. Continue.
Yeah.
Court calls case People versus Unite Singletary. I did that wrong. I know I did it wrong. It's been a long day.
I
Did I
believe
get
you
it
did
right
it well,
this
Your
time?
Honor.
I knew it. See?
Assistant Public Defender Davi Lieb on behalf of Unite Singletary, who appears via Zoom. Ms. Singletary, could you please state your name, ma'am?
Unite Singletary.
See, and I worked really hard, Miss Singletary, to make sure I didn't mess up your name this time. I did pretty good. Aren't you proud of me?
Yes.
Thank you. All right, what are we doing? She's entering a plea.
Yes, Your Honor, I believe that we're already
Are we
done.
sure this time a crime's been committed?
We are extremely sure, Your
Okay.
Honor.
I have before me a plea form that indicates that she's pleading to disturbing the peace, the 90-day offense. Upon her successful guilty plea to that charge, the count one, the possession of a taser, this is very much in the same vein as the other one earlier today, will be dismissed. She is also agreeing to forfeit any interest in the taser currently held by the UMM Police Department or EMU Police Department.
That is correct, Your Honor. If they have been in agreement with Haida,
There was.
Oh, I see it scratched off to the side, but it says Haida. All right, no, that's fine. All right, I just thought. You guys in your paperwork, I don't have defense counsel's signature on the plea form.
Your Honor, if I may approach.
Yes.
Oh.
We did sign it.
Yes.
Where? That's your signature?
Yes, it is.
All right, whatever. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Uni Singletary.
All right, ma'am, it's this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days and or a $500 fine plus court costs. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand?
Yes.
Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You had previously signed an advice of rights form, is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that you will be waiving all of the rights contained on that form.
Yes.
Understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
This isn't a routine plea. This judge is about to do something you almost never see. He's going to protect the defendant from herself.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty?
Yes.
Hang on one moment, Ms. Wiley. Find my information here, I'm sorry. On the date of December 12th, 2024, at the location of Putman Hall, EMU, Eastern Michigan University, City of Ypsilanti, what did you do on that date that makes you think that you're guilty?
Me and my friend were playing around. We're both from Ohio, and we didn't know that the laws are different here, and we were playing around with the taser.
You were playing around with the tasers. You had a taser?
It was not mine. It was the other girl involved with this case.
Your Honor, may I have what here?
That always goes badly, but yeah, go ahead.
Thank you. Ms. Singletary, on the date the judge mentioned, were you and your friend in the hallway at the dormitory with the taser in your possession?
Yes, for about 3 seconds.
Okay, and when you,
Say 30 seconds or three?
3. 1, 2, 3.
well, and while you were doing that, while you were doing that, were you and your friend engaging in each other in such a way where you were holding the taser and that gave concern to a staff member who contacted police?
Yes.
What exactly were you doing, Miss Singletary?
We were playing, me and my friend are both from Ohio. We were playing around with her taser that she had brought onto the campus. I never would have known that there was a taser if it would. It's her taser. We were playing around. We ran into the hallway for about 3 seconds. And once we noticed that, like, we're doing too much, we came back in and now we're here. So
When you say you were doing too much, do you mean that you were saying you were creating a scene that caused attention?
yes.
Is this case related to the other?
No, Your Honor, may I report here?
Sure.
Ms. Singletary, did you chase your friend / roommate with that taser?
Yes. It wasn't my
And did you-
roommate though.
Okay, your friend, and did
Yes.
you arc it, did you activate it while you were chasing her?
Yeah. Can I say something? I'll just say yes. Yes.
Well, no, well. Okay.
Can I
get
say
it.
something?
No, just listen. I know, and it gets hard. This is the second time that we've been through this, and but here's the thing. What I don't want you doing is I don't want you just saying something for the purposes of just saying it. If somebody asks you a question you don't know, it's okay to say I don't know.
Okay, I'm
Or
gonna
just-
say I
but
don't.
What I need. Go ahead.
I'm gonna say I
You're gonna-
don't know to the activating it in the hallway because when we were in the hallway, there was nobody out in the hallway. That's why we were so surprised when the police came. We actually went to we just proceeded with our day. Like we were not even in there when the police came. We never were arrested or anything. That's why this whole case was surprising to me because I never got like arrested. They did end up taking the taser, which because she said it was hers. I never knew it was gonna fall onto me because I never got removed from school. I never got any of that. My friend did, and I never. They said because it wasn't mine, it didn't really have anything to do with it because I don't believe that I activated the taser. I will say that I did have it in my hand in the hallway, but I can't say yes to me activating it in the hallway.
Miss Singletary, while you had the taser in your hand in the hallway, were you chasing the other person?
Yes. But when you say chasing, it was literally a door over, as you can see in the camera view that you have, I believe. It was never down the hallway. There was literally nobody in the hallway.
You guys done?
Yes, I'm done.
No, not you.
I'm
You're
sorry.
good.
I'm sorry. Can I say something else?
Heck, why not? Everybody else has.
Awesome. I just feel like I should, even though I'm saying I don't know to some of these things, I feel like I should just go through with it because my friend did end up going through with hers, but our situations are different because it actually was hers. I feel like if I keep just pushing it back, it's just going to be more and more court dates, you know? This is new. I never had nothing going on like this.
Okay. You know, Miss Singletary, I get it. I hear you. But I hear you, but I am of the belief you don't think that you've done anything wrong as I'm listening to you.
That's what I'm
as
saying, but I understand
hold
the
on,
tape. Sorry.
hold on. But I think you're saying things so you can try to get it over with. And I'm not
Yes.
saying that there's anything wrong with that necessarily. What year are you in school?
I'm in my second year. Next year, I go into actual nursing school.
Council approach. Singletary?
Yes.
All right. Here's what I'm gonna do. Okay.
Mm-hmm.
There are two major concerns here, and I have to make sure before I take a plea that everything at least has been explored and explained to you. Part of the reason that we're here today is because I didn't feel that that was happening the last time, right?
Okay. Yes.
So we're here now. I have some concerns about what your legitimate feelings about your participation in the case are,
Mm-hmm.
and whether or not you're really guilty of anything. And so I have some hesitancy to accept your plea based upon that. But there's a more overriding issue in a certain respect for the court, and that's as to whether or not you've fully been advised of.
Judges are not therapists. They don't usually stop pleas because someone might be rushing, but he just realized something huge. She's in nursing school. A guilty plea here might follow her for life. Licensing boards, background checks, clinical placements. This is the moment the court stops being about punishment and starts being about her future. Viewers, should more judges do this, or is this going too far?
All of the reasonable consequences that are there, including what are called collateral consequences. One of those collateral consequences for you revolves around your education, right?
Mm-hmm.
And what's your aspirations in terms of being a nurse are, correct?
Mm-hmm.
So there needs to be some understanding, or at least an assessment. I'm trying to put this very carefully, but an assessment of what it may mean for your entry and maintaining yourself in nursing school, as well as once you finish that with flying colors, whether or not there may be ramifications regarding licensure. You hear me?
Yes.
Okay. I think all of that needs to be explored and a discussion had with you about all of that before you make some decision about what you're going to do.
Yes, because I was never told about it would affect my nursing.
Hold on. I don't want to know what you and your attorney may or may not have discussed. Okay.
Mm-hmm.
Because I don't get into that, and that is whatever it is. But when I have somebody like you, particularly who's a student, you tell me what you want to do. I know just based upon my experience, and I guess being here since the dinosaurs, what can possibly happen. Okay. And I want that at least talked through with you. It may be nothing. It might be something, but it's a risk, certainly, that you have to assess. And I'm not, and for me, I'm just telling you, Ms. Singletary, the way I look at it, probably wouldn't do any jail time. Probably going to be a fine, then you're done with it. But for me, this is about a bigger picture, and that's what you want to do with your life and your future. So, in that regard, that's a long way of me saying, once again, Ms. Singletary, I am not taking your plea today. Okay?
Okay.
Not going to do it. And quite frankly, nobody can force me to do it, so I'm not doing it. I'm going to adjourn this out to allow that entire conversation to take place so you understand what are not only maybe actual consequences of your plea, but what may be that collateral stuff coming at you, coming up into this next year and even beyond that.
Okay.
Fair enough?
Yes.
I know you said you wanted it over. You mad at me?
No.
Okay, I don't care, but I just thought I'd ask. Okay. Here's what I'm going to do. Probable cause conference in this case is going to be adjourned to November 6th, 2025, 9 a.m. or as your invite indicated. This time the defendant's bond will continue.
Thank you. Have a good day.
Pardon?
You'll keep the plea form in the file?
Yeah, we'll figure it out.
Thank you, Your Honor.
All right. Thank you, ma'am.
You're welcome.
Court calls case, People versus Joanne Thompson.
Assistant Public Defender Jay Bellinger, on behalf of but not with Ms. Thompson, Your Honor, and I am in receipt of the Community Corrections progress report. I will say that I didn't see a lot of progress on there. However, I did talk to my client about checking in with Agent Kerr this morning. I did check with Agent Kerr to see if she had appeared to test and reschedule her CCOP. However, Ms. Kerr said that she was not there and that she had not checked in today.
Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor. Have a great day.
You do the same. Court calls case of the People versus Vershawn Vincent.
Calls for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Vincent, Your Honor. My understanding, Ms. Apple did call in the courtroom and outside. We have tried to reach him. We've had no contact.
I'm sorry.
It's my understanding that we have tried to reach him. We have had no contact. We are endeavoring to do so. I'd ask the court for a show cause.
I don't know why you do that. You know I'm not doing it. I think you just do it to irritate me. Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
I think Gretzky said you miss 100% of the shots you don't take.
It is okay. Court calls the case, People versus Brenton Warren.
Trevor Maybell for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Warren, Your Honor.
Everybody got that M on. All right, what are we doing?
Your Honor, I've submitted a green sheet. We're asking for an adjournment. I think there's some video we need to get a look at.
Has he taken his?
He did, yes, Your Honor. He did. We got the notice from Community Corrections yesterday, and he went shortly thereafter and tested, is my understanding. And
when?
Yesterday around 4, correct?
I tested yesterday. Yesterday I got there about 3:45. I think I wrote on the paper. I have the receipt. I tested a negative.
You have weed?
The receipt, no.
What time did you test?
About 3:45. I wrote down on the paper.
Can you ask? I'll pass the matter briefly. You can have a seat out there. Don't leave the courtroom.
Okay.
Thank you,
We're
Judge.
going to double check. Court does call the case, People versus James Williams.
Trevor Maybell for the people, Your Honor.
Mr. Williams, who should be appearing by Zoom.
We don't have him, and his Zoom appearance would have been revoked.
I'm sorry, say it again.
It would have been revoked because of the violation report.
He says he's on.
He needs to appear in person. Why is he missing?
He's at work right now.
No. Why is he missing testing?
Oh, Your Honor, I didn't
You don't have the violation report?
know, and I looked through.
Well, it's rather empty, so it'd be quick for you to get through because he doesn't go. Read faster than that.
I do.
It can't take that long because there's spaces.
And Your Honor, I have not spoken to my client regarding this test or not going.
Where is
testing.
he now?
He is, he's at work in, I believe it's the Detroit area. Where are you?
We're all in the Detroit area. I don't know what that means. Here's what I'm going to do for you, Miss Cannon. You'll be able to talk to your client. Mr. Williams?
Hello?
Hello?
He's there.
Here's what I'm going to do. I'm going to adjourn your probable cause conference 1 week to October 16th, correct? 2025, 9 a.m. as your invite indicates. you've got some problems with your testing and a violation report, you need to appear at that time, and this will be an in-person hearing. You cannot appear via Zoom. Bond will continue.
Thank you so much.
You're welcome. That was a nice thing I've done today. That's it. Courthouse case, People versus Damian Williamson.
That's both people. So Your Honor, I will get him. He where this dedicated. He was out in the hall with his baby. I'm sorry.
What? He was out in the hallway with the baby.
Yes.
Is that his?
Yes.
Okay. Might need to ask sometimes, Sarah. How you doing? Doing well.
Afternoon, Judge Michael Gaddy, Assistant Public Defender, on behalf of, Mr. to my right, state your name, Mr. Williams.
Damian Williamson.
Your Honor, I have discussed, I have, we have submitted a green sheet here. I'm asking for an adjournment while we continue discussing plea.
I will adjourn. Probable cause will be adjourned to November 6th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you, sir.
Good.
You too. Yeah, no, I'm going. Courthouse case of the People versus Jennifer Burnside.
As well as with people.
Good afternoon, Your Honor. Jason Hagelstorm here on behalf of Defendant Jennifer Burnside, who is present.
Good afternoon. All right. What are we doing?
We're going to ask for adjournment to further discuss some plea deals that are proposed.
Okay. You have a medical marijuana?
Yes, Your Honor, but I am going to surrender it.
Your Honor, for clarification, Ms. Burnside does have a medical marijuana card. She has ceased the use of that at the time of arraignment. There are positive, I received this report on the 12th and the 19th. I would suspect that if there were numbers included, those are going to be decreased, and she's assured me of that. There's a dilute on the 23rd. That is, we're at a loss as to why that would happen. I've advised Ms. Burnside, and she has agreed that if there were errors in testing, she would appear and go to the ER, get a blood test to double verify that. She's taken drastic steps to maintain sobriety. She's attending AA twice a week since the time of arraignment. She's got a upcoming meeting with Dev over at Dawn Farms for an outpatient review. She's participating with the state police Angel program. She has a program peer recovery coach. She's volunteering, and she is attending services with her church as well as Celebrate Recovery on a regular basis. So with those steps, I'd ask the court to consider, and she's been advised that she should check with the facility she tested today. I told her, if you are, make sure that there's not a dilute.
Correct.
We're just
that
at
looks worse than.
And I think, Your Honor, the part of the reason why this case, we did ask for both the scram and the testing is because this is an OWI third offense where there was both a 0.106 in alcohol and cocaine present in the defendant's system.
Correct. Okay. I'll adjourn it out. Will the 30th work for you, counsel? Or you want
30th will work, Your Honor.
Probable cause will be adjourned October 30th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Amber Cormos.
As well as for the people.
Good afternoon, Your Honor. Jay Grant Miller, P58658, on behalf of Ms. Cormos, who stands to my right. Please state your name.
Amber Cormos.
Your Honor.
For an adjournment, counsel.
Yes, we're continuing some negotiations towards possible resolution. We would ask for a date in November as Ms. Cormos is undergoing a medical procedure that might help myself and the prosecutor better lay out a future.
November 13th.
That would be fine.
November 13th, 2025, 9 a.m.
Thank you, Your Honor.
Yep, Bond continue. Court calls case of the People versus Our morale goal.
People.
Good afternoon, Your Honor. Dan Garrett on behalf of Ms. Feldman. State your name.
Armorel, go.
There's a green sheet for screening into sobriety court, please.
All right. Do you know what track they're on and how different? Okay.
I think we.
Which is it for the 22nd, sir? Judge
Go.
Conkey, or which court are you?
Oh, I'm sorry, Your Honor. It's 14A1.
Oh,
Yes, you may know the track.
we're
All
quick.
right. Yeah.
I'll put it out to November, or not November. I'll put it out October 30th,
Perfect.
2025, 9 a.m. Bond will continue.
Thank you.
All right, thank you. Court does call the case People versus Tyler Van Effen.
People.
And again, Your Honor, Dan Garrett on behalf of Tyler Van Effen.
Tyler Van Effen. All right. Requesting an adjournment.
I am, Your Honor, for further negotiation.
Let's put it over that same date for you, October 30th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case of the People versus Beverly Joe Tuttle.
People.
Before 2505 on behalf of Ms. Tuttle, who's on Zoom.
Miss Tuttle.
Good afternoon, sir.
Good afternoon. Okay, you got her. Okay. What are we doing?
Now, we'll request an exam.
No discovery complete.
Yes.
People have their witnesses available the 21st?
We'll try on both cases.
Yes.
Try.
What date, Judge?
The 21st.
Not available on that day, sorry. In a jury trial in Third Circuit. Second day of a jury trial, sorry. I think we'll be done. So I'm available on the Thursday, the 23rd, or it has to be a Tuesday.
You've been coming here how much?
I don't recall.
Then you should know what day our exams are held. It's Tuesday. The 28th.
I'm available, Judge. Thank you.
Preliminary examination in person, October 28th, 2025, 9 a.m. That's before Judge Washington.
Thank you.
Thank you, Judge.
Bond will continue.
Thank you.
Well, I'll see how far I can get through before I have to rest my weary head. Court calls the case People versus Anthony Alexander.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Alexander. Could you please state your name?
Anthony Alexander.
All right. And you're doing the plea?
Yes, Your Honor.
All right. I have a plea form that indicates he's going to plead to an added count 2 of larceny, attempted larceny, less than $200, and a 6-month offense, 6 months possible incarceration. Upon a successful plea to that charge, count 1 would be dismissed. There is a sentence agreement of 12 months probation with no from jail in Haida. Although the court, I cannot bind the sentencing judge. I do acknowledge that that's an agreement between the parties. There is one thing that was not checked on this. You did explain to him that I would not be a sentencing judge and he would be sentenced before Judge Barr.
Yes, Your Honor.
All right, because the sentencing judge box was not checked, but I will check that. All right. That's a correct statement of the agreement?
I think it was attempted larceny over $200 and less than.
Yes.
Okay.
Attempted larceny over 200, the 6-month offense.
Yep, all correct, Your Honor. Thank you.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
State your name.
Anthony Alexander.
All right, sir, it is this court's understanding that you are going to be pleading guilty to a charge of attempted larceny, $200 or more, but less than $1,000.
Yes.
That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. You understand that? You understand that the fine could be increased at 3 times the value of the property taken. If that's greater than $1,000, that could become the maximum fine. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. You'd be sentenced before Judge Barr in the 14A2 District Court.
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of April 9th, 2025, Sellers Hall, number 521 on EMU's campus. What'd you do on that date that makes you think that you're guilty of this charge?
Attempted to take a television.
We have, there's 3 cases from the same incident. If that's why you looked up, because it sounded familiar. There was one earlier today, and this is the second.
This is the second, and then there's another one.
Wrap them all up.
Hold on a second. Did they all try to take the same TV?
There was other property in the room that
Okay, but everybody keeps saying they're trying to take, it's a 24-inch TV.
there was other property.
I don't think they even call that a TV now. You tried to take a TV out of that?
Yes.
Okay, and you didn't have any property interest in that TV? Meaning it wasn't yours?
No.
No? You understand that if and the value of that TV was in excess of $200?
I'm not sure.
Okay, so was other property taken?
No.
Just the TV?
TV wasn't taken either. It was attempted.
You had 2
Which is why you had the attempted gun.
It was a nice TV, Judge. It's probably.
So the cases inside. So I thought it's time for us to really think about.
Would you stipulate that the value of the TV was in excess of $200?
Yes.
Thank you. All right. Sir, if I accept your plea, you understand that if between this time and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, that the judge would not be bound by any sentence evaluation or recommendation. You understand that? And you also understand that you would not be permitted to withdraw your plea.
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
And has the court complied with the court rule? And would it be, and can I accept this defendant's plea? Let me put
Yes.
that.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
October 29th at 10 a.m.
October 29th, 2025. What time?
10 a.m.
10 a.m. before Judge Barr.
And Your Honor, Mr. Alexander.
Are you in school?
Yes, sir.
What year?
I'm currently a senior.
You're a senior?
Yes.
This happened when you were a senior?
No, it happened when I was a junior last year.
Oh, so you're just smarter now.
Yes, sir.
What are you studying, or what did you study?
I'm studying business administration.
Why would you get yourself involved in something that could mess everything up for you?
It was really a wrong place, wrong time. Actually, more of a wrong.
I raised kids, so I know that's not an answer. That means I don't want to answer your question. Why'd you do this?
I was with people who stayed on campus, and They left their room. I followed suit because I didn't live on campus at the time, which I do now, but I followed suit. And it just happened to be a 30-second interaction that led to this court going to jail for a day.
Where are you from?
I'm from Inkster, Michigan.
Pardon?
I'm from Inkster, Michigan.
Well, I know the school, but where'd you grow up?
Inkster, Michigan.
Hey, oh, Inkster. I thought you said I'm from Eastern Michigan.
No, no, no.
Oh, you said
Inkster, Michigan. Yeah.
You know better than this, right?
Yes, sir.
What would you say to your family if you weren't able to graduate?
I messed up.
Yeah. How's that gonna work? Yeah.
They'd be disappointed.
Probably a little more than disappointed, but okay, it's fine. We'll continue.
I had one request, Your Honor.
Oh, no way.
I know. You're not going to be happy with it, really.
Oh, good. After today, yeah, let's do things that just upset Judge Simpson. Go ahead.
He has a school trip to Ohio tomorrow, Your Honor, and he's asking permission to leave the
For
state.
God's sakes, why?
I know. I knew you weren't going to.
Why do they want to go to Ohio?
It's a campus involvement event to build community and fellowship.
To do what?
Build community and fellowship.
In Ohio?
Yeah, it's going to Cedar Point, but it is a friendship event with multiple orgs involved. It's multiple organized.
You know what? The way you spun that, you need to become a lawyer. Wow. When are you going?
Tomorrow at 10 a.m. 10 a.m. coming back at 10 p.m. So
10 to 10?
Yeah, 10 to 10.
Okay, we locked the border at 10:01. Yes, major travel to Ohio. He can travel to Cedar Point. We put Cedar Point on the order, right? So everybody knows where he's going. Okay, good. All right. Thank you.
I appreciate you.
Thank you.
Have a good one.
Check your email later.
Court calls the case of the people versus Malachi Harris, aka Malachi.
Good afternoon, Your Honor. Christina Costantino appearing with and on behalf of Mr. Harris. Mr. Harris, can you state your name?
Malachi Harris.
Thank you.
Oh, gee.
You'd see me at some point today, Judge.
What?
I
No,
knew you'd see me
actually,
at some point.
see, you don't understand. I saw you, and that actually brought joy to my day.
Oh, that's
It actually did. This has been anybody. It was a rough day, and I said, you know what?
That's
In the
great.
last block, Constantina's going to show up. It's just going to brighten the whole thing
That's great.
and
You
make
know,
all the effort and turmoil that these rest of these people put me through today worth it.
for sure, Judge. For sure. You're almost through. You're almost.
Yeah,
You're almost. done.
Almost. I'm getting there.
Almost Friday.
All right. I have a plea form. Is that what we're doing today?
Yes, Judge. We are
All
taking.
right. Plea form indicates that it's going to be attempted larceny, $200 or more, but less than 1,000. The 6-month offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also an agreement to 12 months probation, no from jail in Haida. The sentencing judge waiver was not signed, but this is Judge Barr's case. Did you explain to him that?
Yes, Judge. We did discuss that. It just wasn't checked on the box.
Okay, and I will check that on the form. All right. May I have him sworn?
Right here. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Malachi Harris.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted larceny, 200 to 1,000. That is a misdemeanor punishable by up to 6 months incarceration, a $1,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than 1,000, that would become the maximum fine. You understand that?
I do.
All right. You also understand that I would not be your sentencing judge, although I'm taking your plea. You would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Sir.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. Understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record that you can plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty of this offense?
Yes.
Oh, boy. April 9th, 2025, at the location of Sellers Hall, Eastern Michigan University, Washington County, State of Michigan. What did you do on that date that makes you think that you're guilty?
Your Honor, may I voir dire?
Is it involving a TV?
It is,
Because
Judge.
I'm almost going to come off this. Go ahead.
It is. Mr. Harris, on April 9th, 2025, were you at the Sellers Hall location in Ypsilanti, Michigan, located in Washtenaw County?
Yes.
And on that date, did you attempt to take some items that you did not have permission to take?
Yes.
And were those items a TV and some other miscellaneous house furnishings?
Yes.
Okay. And the value of those items, would you agree, was over $200, but less than $1,000?
Yes.
And you did not have any permission to take those items, correct?
Yes.
With that, the defense would be satisfied, Judge.
Sir, I do have to advise you, if between today's date, if I accept your plea, between today's date and your time of sentencing, if you commit misconduct as defined under the Michigan court rule, you first of all the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I do.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea agreement?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2. Probation sentencing will be
October 29th at 10 a.m.
October 29th, 2025, 10 a.m. before Judge Barr. You're a student?
Yes, sir.
What year?
I'm in my senior year.
This happened in your junior year?
Yes, sir.
So you're like what the last guy got smart.
Yes, sir. Yes,
What's your major?
I major in communication with a double minor in marketing and psychology.
Oh. You figure out the psychology of why you did this mess?
It's just a bad decision. Wrong place, wrong time.
I don't know what that means. Wrong place, wrong time. My kid tells me that. That means you did something. Where are you from?
I'm from Detroit, Michigan.
You're from Detroit.
Yes, sir.
The Big D. Right?
Yes.
Do some. Is a 24-inch TV?
Yes.
Why? I mean, really, why? 24, I could not see a 24-inch TV. I would not know that there were people on it.
Just a bad decision.
So what would your family say if all of a sudden this messed up all your future plans?
They would really be disappointed in me. They would tell me I've come too far and broke too many generational curses to even put myself in this situation, honestly.
See how Detroit's changed? Because I can tell you what my parents would have done. They would have involved a switch, maybe a whole stick. Wouldn't have been a lot of words. Nope. And they'd be right about that, wouldn't they? You don't do these things to mess up your future. You have come too far.
For sure.
All right, he answered my questions. I don't have to revoke his bond. I'll continue it. Second, I'm not going to lock him up.
Thank you.
Thank you, sir. Take care.